My name's Brandon Lawson. I'm a senior associate in Kansas City, and I've put together today's Kansas update. I do nothing in Nebraska and Iowa, so you'll have to wait for Bill to pepper him with those questions. But see what we can do. With respect to Kansas this year, it was kind of sparse on the case law side of things. A lot of the stuff that was coming down was from the board and was simply a review of facts and determining whether or not the board members agreed with the findings of fact or not. And those really don't provide us much instruction other than a broad overview of how the board seems to be handling those types of things. So I've largely ignored them in today's presentation materials, and instead I'm trying to provide you with a general overview of Kansas work comp now that we're about 4.5 to 5 years into the 2011 changes. 2011, Kansas completely overhauled the Workers' Compensation Act, as I'm sure most of you or anybody that has experience in Kansas knows. There were several controversial decisions that spurred that, and it largely fixed most of them. Causation, work disability, and future medical treatment were the big issues that the legislature addressed. Causation has been changed to a prevailing factor standard from the very, very liberal aggravate, accelerate, or contribute to standard that had been there before. The work disability was completely overhauled, and we'll get into the specifics in a little bit as to how the judges have been handling it. But basically, when we're now considering work disability, it's a standard based on the capability of the claimant to earn wages instead of just solely how much they were working. And future medical, as in the past was simply for life, subject to negotiation, they now have to meet the standard that it's more probably true than not that future medical treatment will be necessary. With these statutory changes, of course, it largely depends upon how the judges interpret them as to what they mean for us. The Court of Appeals has provided very few, if any, answers to this point. Court of Appeals and the Supreme Court in Kansas are very slow. I have a couple of decisions, perm total decisions that are on appeal to the Court of Appeals right now that we will hopefully have decisions for you to discuss this time next year. But at this point, the Court of Appeals does not have any guidance for us on the changes. The Appeals Board is still the main source of law. The Appeals Board will look to itself for guidance, but for the most part, of course, it is not as authoritative as if we'd had higher courts interpreting the law for us. Overall, the decisions from the board that have been out there are very mixed, but for the most part favorable to our view of the world. First, let's talk about the good things coming from the board. The causation opinion. Neutral IME doctors are still the main source in Kansas. The typical case in Kansas, if you have causation concerns, is they're going to get their opinion from their doctor. We'll get an opinion from our doctor that, of course, disagrees. So the judge will either appoint a neutral, or if the parties can agree on the doctor, will then select that doctor to settle the issue, basically be the tiebreaker. In a lot of ways, much easier than those of you that handle Missouri claims, where it's kind of up in the air as to how it's handled. The judge will 99% of the time do exactly what the IME doctor tells him to do. The main thing coming from these decisions is that the prevailing factor standard in Kansas seems to be a little harsher than it is in Missouri. Even though they're the exact same language, it does seem to be getting more, and there's a couple of reasons for that. The Kansas statute explicitly indicates that an injury is not compensable because it solely aggravates, accelerates, or exacerbates a pre-existing condition. The judges are keying in on any magic language such as this in any opinions from a doctor to deny or not deny a case. If we have a decision or an opinion from a doctor, it is very helpful if that doctor can state, and we know there's pre-existing issues, if that doctor will tell us that the injury has aggravated, accelerated, or exacerbated that condition, and that's all it's done. If you're reaching out for a doctor for our cases, that's the language we're looking for, in addition to saying not prevailing factor. One of the things on the flip side of that, though, is that Kansas defines injury as a physical change in the structure of the body. Oftentimes, this will trump prevailing factor in some of the judges' decisions, and I think that's somewhat a misreading of the statute, but that's the way they seem to be doing it. If, for example, there's a knee injury, there's an MRI of the knee that shows there was a specific change, even if the doctors seem to be of the opinion that change was because of pre-existing conditions, because that physical change of the structure of the body occurred, the judges really are latching onto that to try and give the claimant something if that has occurred. Another key factor in making causation or the prevailing factor standard in Missouri in Kansas a little stronger than Missouri is that applies to treatment as well. One of the controversial things that's happened in Missouri is the Tillotson decision. In that decision, it was basically the opinion that the court believed that there was prevailing factor for the injury and some treatment. Then the question became, was the knee replacement necessary because of the work injury or the pre-existing? The doctor's testimony was essentially that I can only treat the work injury because of, with the knee replacement, inclusive of everything that was there before, it all flowed together. Kansas, that's not good enough. The statute explicitly says prevailing factor applies to the medical condition, the need for treatment, and the existing or resulting impairment. Based on that, we are able to deny additional treatment much easier in Kansas than we are in Missouri. From a practical standpoint, the advice we would give based on this is that we need reasoning from the doctor. A one-sentence or two-sentence report from our doctor saying the injury is not the prevailing factor is not going to cut it. The better reasoned opinion doesn't necessarily always prevail in that sense if they go to the IME, but we are then giving the IME doctor reasons why, and that has helped influence the IME doctor from our standpoint because our doctor's giving him some reasoning as to why he believes the way he does. And like I'd mentioned, the judges seem to be responding best when there's language including the notion that the claimant has only suffered an aggravation of a pre-existing condition or no change in the physical structure of the body. TTD has come out much better. One of the key problems in the act before was we would get stuck in situations where we're arguing over causation. There's restrictions in place that the whole time while we're arguing, and as a result, we would end up having to go back and pay TTD for a significant amount of time while that stuff is being litigated. The Act has changed that, and the judges are enforcing it fairly well in that TTD is only commencing from the time the authorized treating physician has the claimant on restrictions that aren't accommodated or takes them off work. What that means for us is that if we provide a minimal amount of treatment or some treatment, and our doctor releases the claimant then goes and gets their own opinion with restrictions and recommendations for more treatment. Ultimately, if we have to provide more treatment or they're taken off work by an authorized treating physician after that, we do not have to cover TTD for the whole time frame. It will only be for the time frames that the authorized physician has them off work. Work disability is another good from the changes and how the judges are interpreting it. Work disability is now going to be based on the evidence of wage loss coming from vocational experts. In the past, it was simply math. If a claimant was not working, there was 100% wage loss because they had no earnings. That's all the math you needed. The claimant's experts are now relying heavily on the availability of jobs in the open labor market, regardless of for anybody that I don't think anybody in the room lives in Kansas, but regardless of your opinion of the political situation in Kansas, jobs are an issue. The governor may tell some other people otherwise, but there are areas where jobs are a bigger issue, and they're latching on to the claimants not being able to obtain work in the labor market in the area in Kansas in which they are. That is one of the factors listed in the statute It seems to be getting overly relied upon, and to that extent, we may need to begin using more vocational experts from our end. Respondents, vocational experts, are relying heavily on the restrictions affecting the ability to perform job duties. The essential notion here is that if you are not on restrictions or on fairly minimal restrictions, then it shouldn't have affected your ability to do any of the jobs that you were doing or did in the past. Claimant must now show at least or more than 7.5% impairment to get work disability, or 10% if there's pre-existing. This is causing some problems in settlement negotiations, in that if we're in a case where, for example, you've got the doctor's rating, one has a 5% and one has a 10%, and there's some restrictions in play, well, it's going to be harder to settle now than before, because we're looking at that 7.5%. Is it going to be more than 7.5% at trial? Who knows? That's a difficult call to question to answer when you're at a 5 and a 10 to split. If you get more than the 7.5%, all of a sudden you're in the work disability threshold, greatly increasing the potential exposure on the case. Those numbers, as a result, can make those types of cases harder to settle, because we're in an area where if you're just talking 7.5% of the body, that's not that big of a deal. If you're into work disability, you can easily get up closer to 30, 40, even 50% of the body as a whole, with some even fairly minimal restrictions. Notice has become a strong defense, though there are some loopholes that are starting to cause problems as we come across those situations. Everybody's quick to criticize people that draft statutes, but it's hard to imagine every possible scenario when you're coming up with language, and it's clear there are some loopholes they did not anticipate or adequately explain when they were drafting these language. Notice is now required within 20 days from the date of accident or date of injury by repetitive trauma, within 20 days from the date of medical treatment, or 10 days from the date the claimant last worked for the respondent if they don't work there anymore. The problems are coming in with the second one, 20 days from the date medical treatment is being sought. The statute leaves it as that, simply within 20 days from the date medical treatment is sought. The board, however, has determined that means within 20 days of medical treatment sought following the date of injury by accident or repetitive trauma. The problem comes in, and that means that that section has absolutely no difference than the section before it. But that's the way they are interpreting it. The problems we're seeing with that means then that claimants who obtain a significant amount of medical treatment on their own, unauthorized, then come in and say, well, I think my problems are work-related. Usually we're talking repetitive trauma instead of accident in these types of situations. And because no doctor has diagnosed it as work-related yet, or told him he needs restrictions because of it, there hasn't been a date of accident or by repetitive trauma. And for that reason, we're still finding that some of these cases where the claimant is treated for, one I had was even up to 1.5 years, unauthorized treatment, are still being found compensable because there was nothing to ever establish a date of accident or date of injury by repetitive trauma. I think these are issues that are ripe for the state legislature to do something about, but at this point that doesn't seem to be anything they're too concerned with. But one thing on the notice issue to be concerned about is we need a full story on cases of repetitive trauma for any and all treatment the claimant would have received before they report it to their employer. Anytime the claimant is getting unauthorized treatment, if restrictions are what we are looking for, or being taken off work, or being told by their doctor that it's work-related. Those are the keys that we need to establish the date of injury. Other good results within the fighting area. Prior to the changes, it had simply been case law establishing that if you're fighting or in horseplay, it's not work-related. It is now statutory. Voluntary fighting or horseplay is not compensable. Case law beforehand had kind of held something to the effect that if the employer knew about it and did nothing about horseplay over a period of time, then that became fine. Or if the employees were arguing or fighting about work, then it was still within the course and scope of their employment. decisions from the board has overturned both of those. If you are voluntarily fighting or in horseplay, it's not compensable, period. There are no exceptions. The case law prior to the changes has been changed to that effect. Arising out of and in the course and scope of employment has seen good decisions. One key that seems to be coming into many of the decisions and ones that we've been successful on, if you're going on smoke break, you're not in the course and scope of your employment. The ones where we get really fact-intensive problems in a lot of this type of stuff as to whether or not you're still in the course and scope of employment are, breaks, lunch, walking to the bathroom, those kind of things. The key distinction the appeals board seems to have made with the act as it is now is that are you doing something that you have to do regardless of your work? For that, they're talking about drinks, bathroom breaks. If you're clocked out for lunch, not so much, but if it's a quick break, those kind of things that are just simply necessary to the human condition, regardless of work, they're probably still going to be compensable. Smoking is not something you have to do because you're a human being. The appeals board really seems to be taking a fairly hard line that if you're going to your smoke break and slip and fall, it's not compensable. That has been the biggest key factor on most of those decisions is that you don't have to go to smoke break. The one we've tried, the claimant slipped and fell on ice on the way to smoke. You don't get anything. Future medical treatment is one that is starting to come down on the bad side despite the changes. As I indicated earlier, the statute now says that to get future medical treatment, they have to show it's more probably true than not that future medical treatment will be necessary. It does not say the doctor has to tell us what treatment will be necessary, just the treatment will be necessary. Claimants are still demanding consideration to close future medical treatment, even if the doctors do not address or indicate that future medical treatment will be necessary. The key example in these is that Dr. Prostick and some of the others really don't address future medical treatment in their reports when we get it in. So, of course, it's initially our opinion, well, we're not going to pay you anything because your doctor doesn't tell us future medical treatment's necessary. Then we come to the hearing portion of it, and of course the doctor adds that opinion as soon as he gets in deposition and says, well, no, I believe X, Y, and Z will be necessary, and here's why. That's how they're trying to get around that issue. But for the most part, we're not talking significant consideration. We're still having to throw in on a lot of cases an extra $1,000 or $2,000 to get them to close future medical treatment despite these changes. Several ALJs, namely Judge Hirsch in Lenexa, indicated their preference for future medical. A lot of that I think is probably simply that's how it was the entire time he's been a judge. That's how he likes to see it, and he's reluctant to change that despite the fact the statute did so. So some of our experience on this is going to be based on what judge we are in front of. And then lastly, case law, similar to Missouri, if there's hardware in there, future medical treatment will be left open, period. That can be negotiated, unlike Missouri, but if it goes to trial and there is hardware, the appeals board has indicated future medical is to be left open. Another bad, injuries to parallel extremities are now body as a whole again. For those of you that have been in Kansas long enough, prior to Casco was the name of the decision, if you had bilateral carpal tunnel, bilateral elbows, bilateral knees, something that was parallel, that became body as a whole. Case law did away with that. Then when they changed the statute in 2011, they put that back. Based on this, we are seeing increased demands for work disability based on bilateral carpal tunnel, bilateral epicondylitis, and other types of similar complaints. Drug tests we've mentioned in the past. Kansas did strengthen the ability to deny cases based on positive drug tests. The problem is getting those tests admitted into evidence. Positive drug tests from our doctors are not admissible unless a split sample is offered to the claimant within 48 hours of the test. The problem is coming in and because frequently neither you nor us are able to get to the doctor within that 48 hours of time to make sure that happens. And as soon as that condition is not met, then the case isn't compensable. Or the case is not admissible. The drug test is not admissible. This does not apply to doctors that we do not send him to. For example, if there's a car accident and an ambulance simply arrives and takes him to the emergency room as you would expect, that treatment is not being done at our choice of doctor or at our indication. As such, these rules don't apply to that. There's some things about that still aren't quite clear, but the key thing we need to understand is that we need to impress upon the clinics that typically are the first treatment for us, the U.S. Health Works and Concentra and all those types of folks that often see the injuries. They need to understand that if they are taking a drug test, the employee has to be offered a split sample. I'm sure the employee is absolutely sitting there waiting for half his sample to come back to him, but the statute says we have to do that. Continuing, just a few more things with the bad. Post-award medical, attorney's fees still available. This is often something that's basically a gun pointed at our head to offer future medical because we end up having to pay the attorney's fees for the claimant if they do file that application for post-award medical. Temporary partial disability, we are running into problems because it expanded temporary partial to all injuries, not just body as a whole, but there still is no standard or definition of what constitutes temporary partial disability. They are frequently asking for temporary partial simply because the claimant is not getting the same amount of hours as they were prior to the injury. Well, in our opinion, that's not sufficient. There still needs to be some connection between the wage loss and their claim for temporary partial, but the statute has not given us any guidance as to that. A couple of things in the unknown. As of January 15th, 2015, all injuries will be assessed impairment based on the 6th edition of the AMA guides. As I understand it, if there's anybody in the room that also handles Illinois claims, that's what they've been using for some time, but the claimants' attorneys in Kansas are freaking out, to say the least. The sky is falling. We will all be out of business, they tell us, in the near future because they are so conservative in the 6th edition is what we're being told. We don't know anything yet. That's the basic gist of this. The guides do seem to be more conservative. There seems to be a smaller range of impairment for most injuries and sticks with diagnosis far more than the 4th edition, but the future will tell whether or not there are really any changes. My hunch is that the judges will still find ways to award disability and impairment somewhat lower because they'll have to, but at the same time, I don't think they will keep us too far out of it. Closing future medical. The statute has now provided us a window if the claimant does not seek future medical treatment within 2 years of the date of the award to have it closed. There have been no cases addressing what the claimant can do to stop that. The statute says good cause. We still have no idea what that means. There's absolutely no guidance, so it's hard for me to sit here and stand here and tell you what they're going to be looking for, but at this point, we simply don't know. Lastly, the coming and going rule is still no great bright line answer to the statute in this. They are very fact intensive. I know Brian and David and I and Tom get very frequent calls of, oh, somebody's driving here or there, is it compensable? Well, those are the cases where we need to know just about everything you can possibly tell us about the accident before we can determine numerous facts, including whether they're on the clock, whether they're in a company vehicle, were they going for a company task, were they on the way home, were they working from home, and any other number of facts go into determining those issues. These are about the most fact-intensive determinations there are in the Kansas in the Kansas Act. There are case law summaries of a few things that came out in the booklet. I'm largely passing over those because none of them are too ground shaking, but there are a few things in there, and I need to give Bill some time to speak as well. So if you have any questions about Kansas, just let us know, but that's kind of where we stand now, about 4 years out from the changes that have been made. Oh, one other thing, I did want to share some good news if you haven't heard yet. Everybody's best friend in the state of Kansas, Judge Brad Avery, anybody that practices in Kansas has to know that name, is the most liberal judge I've ever seen in my life, has been terminated. His last day on the bench will be June 23rd. I think I have a few cases, maybe a trial even for one or two of you, that we will be trying to drag out a little bit, and my apologies for trying to drag that out, but that's mostly to make sure he doesn't get to be the one to make the decision before he leaves. So good news on that front, but overall, we're looking better in Kansas.
All right. Is this working? So I guess we are videotaping this, is that right? Great. Okay. Can everybody hear me okay? I don't like to stand behind a podium, so I'm going to make it difficult for the AV guys. Here, try this. Okay. Time is limited, so I'm going to kind of go fairly quickly through two states, Nebraska and Iowa. But because of that, and because you guys obviously came in here to get as much benefit as you can, interrupt me with a question, by all means. If you have any questions, because the amount of material I can cover in here is limited, I might as well hit things that you want to know about. So by all means, just interrupt me, raise your hand, do whatever you need to do, and off we go. One of the things I want to start with in Nebraska, which is probably one of the most simple things that your clients, our employers, have to deal with, which is the Form 50, which basically is literally a form that gives the employees the right to designate who they want to be their treating doctor, because in Nebraska, that's their right. Unfortunately, many employers don't follow the rules and don't comply with the requirements of Form 50. A lot of reasons why they don't do that. One, it can be kind of an administrative hassle, but nonetheless, it's something that they are required to do. Let me kind of zip through here. The law states that an employer must give an employee notice of their right to designate their own treating doctor as soon as possible after the accident happens. I get a question a lot, well, how soon is as soon as possible? As soon as possible. Okay, is it in the ER when they're in there getting treated right after they fell off a ladder? No. But within a couple of days, by all means, you need to give them that notice. It does not mean when an employee is first hired and you're having them fill out their new hire packet of all kinds of HR documents, and you slip a Form 50 in there hoping that they're going to ignore it or maybe indicate that they don't have a treating doctor, and then you can then use that to control medical care down the road. Some people do that. It doesn't work. Okay? They like to try and do that because an employee typically isn't thinking, what happens if I get hurt? I want to go see my doctor. But the law says you have to give them the notice after the injury. So after the injury does not mean when you hire them. Pretty simple concept. Apparently some people still haven't grasped it though. Here we go. If they're not told of their right to choose their own doctor, and it becomes an issue later on. It's very common, and I was just having a conversation with someone a few weeks ago, that an employer will try and direct care. They've got their work comp clinic set up, they've got an occupational physician that they like to funnel people to, and it's okay if the employee wants to go along with that, but if they still weren't advised of their right to pick their own doctor, and you start having them treat with the OCMed clinic down the road, and 6 months later, they kind of decide, well, I really don't like this doctor, the treatment's not going well, I want to go see my own doctor, they're going to get that option, okay? If the employer did not give them the Form 50 or in some form or fashion advise them of the rights required by Rule 50, and they later on decide, well, I want to up and change doctors, I want to go see my doctor, they're going to get that right. And the first question that I'm going to get from their lawyer when they go out and get one is, where's the Form 50? Show it to me. I want to see it. And if I have an employer who didn't give it to them, then things are going to stop. They're going to go see their new doctor. The employer is going to be upset because maybe it's going to be a whole new course of care from that point on. But nonetheless, that's something that can often happen when the employer doesn't follow the rules from the start. And I know that's difficult, obviously a difficult spot for you guys to be in, trying to tell the employers that they did things wrong early on. So I often encourage adjusters, if you've got someone that's being difficult to deal with or they don't quite understand the rules, call me. I'm more than happy to have that conversation with a risk manager or an HR manager and help them understand the importance of following Rule 50, the pitfalls that can happen down the road, and they are great, certainly, if you have a course of care that's going to be interrupted. So you really need to, get that train on the right track early on and prevent a lot of problems down the road. Another question I get is, well, the employer didn't give it to them, can I? Yes, absolutely. If you need a copy of it, I can give you one. If you can't get a hold of me, it's on the Nebraska Work Comp website. There's a list of different forms that's on there, and you can just print it off and send it to your claimant, explain it to them, although it's fairly self-explanatory. But by all means, if you want to give that Form 50 to them and have them designate a treating doctor or not, absolutely you can do that. Obviously, if the claim is denied, they get to see whoever they want, family doctor or no family doctor. One of the points in one of the previous slides had to do with if they do want to choose their family doctor, can you verify that that is in fact their family doctor and they have a treating history? Yes, you can. They have to give you that right. If they don't, then they kind of lose the right to see that doctor. And that doctor can include a chiropractor, believe it or not. Okay. Again, I mentioned that this is a simple issue to deal with initially. There have been some cases, and I'll touch on them in the case law update. You all have that in your materials, where one of them in particular, the injured worker did designate that they had a treating doctor in mind. They started treating with that person. The insurance carrier was not very quick to pay the bills, essentially. And this went on for probably better than 30 days. Long story short, the court ruled that because the insurance carrier was not paying the bills timely, they in effect denied the claim, which then let the injured worker choose whomever they wanted to see. And in this case, there were not only referrals from the original treating doctor, their family doctor, but this person decided to go see a bunch of other specialists, completely outside of any chain of referrals. And the court awarded payment of all of those bills, no matter who they came from, because in effect, the employer had denied the claim just because they took too long to pay the bills. So things like that can creep up and cause a lot of very serious problems down the road that are obviously very easily avoidable. Any questions on Form 50? Again, it's a pretty simple matter. Again, it's on the Work Comp website. If you do have questions about it, don't hesitate to contact me at any time. Something else that's fairly unique about Nebraska versus Iowa, and it sounds like some changes are kind of coming down the road in Kansas, is the use of vocational rehabilitation. It's something that injured workers are entitled to when they have certain types of injuries, those being injuries to the body as a whole, as opposed to scheduled member injuries. It's kind of a long process that involves the parties hiring a vocational rehabilitation specialist, and there's kind of a process that we'll follow to do that. But once a vocational rehabilitation counselor is engaged, their goal is obviously to return that injured worker to as close of the same type of work as they were doing as possible, but there's a hierarchy that they'll follow, and this kind of explains it. If they can't get them back to the same job with the same employer, they'll go down the line and try and get them back to similar work. Worst case scenario may be that they recommend a period of formal retraining, maybe a couple of years at a community college to teach this person how to be an architectural drafting specialist. That kind of program is not unusual, especially for younger injured workers, maybe someone in their 20s or 30s who has the capability of returning to school. Obviously, if you have a 65-year-old injured worker who's been a truck driver for his entire career, you're not going to send him back to school, but nonetheless, it's an option that will be addressed by the voc counselor. Those counselor services are paid for by the insurance carrier or the employer. You also pay for temporary disability benefits during the time that injured worker is in the plan. That can be a big expense because in Nebraska, the TTD benefit rate is often significantly higher than the PPD rate. And if any of you have any questions about how to calculate that, again, feel free to ask me. I believe we have some materials in the workbooks that you had that include kind of an example on how to calculate those rates. But it obviously can be a pretty significant expense, especially if you have someone trying to go back to school. They can refuse to do that. They can decline those VOC benefits, but again, that's up to the injured worker. And I'll kind of, let's see how we doing on time. Not too bad. In addition to someone who has a back injury, for example, that's a body as a whole claim, someone else can still be entitled to a loss of earning capacity evaluation to vocational services if they have two injuries to, let's say, both shoulders, okay, stemming from the same workplace accident. If those two injuries combined to produce a loss of earning capacity of at least 30%, and that's obviously determined by the voc counselor, then they can get loss of earning capacity benefits in the same way that someone who has a back injury can get them. Obviously, that's something that you won't know when the injury first happens. You may not know what that result will be based merely on the doctor's reports or any impairment ratings, but it's certainly something that they can request. It's not something that you necessarily have to affirmatively offer them, that kind of an evaluation, but if they have an attorney, they're probably going to do that. If they have bilateral injuries of any kind, they're going to want to have a vocational evaluation. That's a quick Nebraska look. I want to talk about a couple of quick cases that are also in your materials. They start on page 113 in Nebraska. A variety of different cases that kind of hit on some controversial topics sometimes things that get employers kind of worked up. Obviously, the first one that I have on page 113 or 114, Clark versus Legion Health, that's the case I was referring to with regard to the misuse of the Form 50. So I won't go into a lot of detail about that due to time constraints. The next one in the outline, Simmons, had to do with medical expenses and what was considered reimbursable. Often that's a big controversy. What kind of services does the insurance carrier, do the employers have to pay for? In this particular case, you essentially had an injured worker who required 24-hour a day, 7-day a week nursing care, including overnight in his home. The fighting issue in that case basically resolved around the use of a wheelchair accessible van, which they were awarded, but it also had to deal with the injured worker's wife providing overnight nursing care and then wanting to be compensated for that care. Obviously, the insurance carrier didn't want to pay for that. The court said no. The doctor said you need 24/7 care, and if you're not going to have a nurse do that, in this case they started having a nurse do that, but then switched to the gentleman's wife, then that person, the wife, is entitled to some reimbursement. And the court basically gave her $10 an hour for a number of hours per week. I think it was 108 hours per week. So they had to pay this person's wife, even though she was sleeping during the overnight care, even though she was technically on call, not doing anything for maybe 90% of the time. Court said, well, somebody's got to be doing it, and if it's not a nurse, who you're going to have to pay for, and if it's the wife, then so it's the wife. You're still going to have to pay. So just kind of an example of some of the different types of medical care that you might have to pay for. Skipping forward to the Rogers case, that had to do with the issue that I've got mentioned here, which was a person who had bilateral injuries, so wasn't necessarily entitled to a vocational evaluation unless it reached that threshold, which in this case it did. The fighting issue in that case was, well, the gentleman only had restrictions on one of his legs and not the other. So the defendants contended that because he didn't have restrictions on both legs, he shouldn't be entitled to the vocational evaluation. Court said no, doesn't matter if you have restrictions or not, you still get that evaluation, and in this case it did exceed the 30% threshold. I get a lot of questions from adjusters wanting to know if we can deny benefits because the injured worker isn't being compliant with treatment. He's not going to his appointments, he's not taking the medication, so on and so forth. That's a very high bar to get over. In this particular case, Mr. I'm not sure how to pronounce his case, Boger, decided that he wasn't going to treat his blister on his right big toe properly by taking medication, staying off his foot. He wasn't using crutches. He basically wasn't complying with any of the treatment. Fast forward a few months down the road, and he loses his big toe, gets amputated. Court said, well, you didn't comply with any of the doctor's treatments. You didn't stay off your feet, use the crutches, et cetera, et cetera. We're not going to make the defendant pay any of the bills other than the initial doctor's appointment. So that's all they had to pay in that case. Kind of a rare circumstance, but nonetheless, maybe a glimmer of hope if you have an injured worker who's not complying with care as he should. If you can document that very well, you may be able to avoid paying benefits. Let's fast forward to Iowa now. Not a whole lot of changes really in either state substantially. Surveillance was one of them. Spend just a half second only to say that surveillance is now treated essentially the same way as medical records, meaning we have to disclose it right away. We don't get to sit on it and decide whether or not we're going to use it at trial. If surveillance is done and the other side asks for it, they get it. Okay, that's thanks to our now no longer present commissioner. Maybe one of the bright spots in Iowa is that we do have a new commissioner now. He's got a little bit more of a defense background, so we'll see how that plays out. But on his way out, the old commissioner wrote an opinion that basically said surveillance is essentially a form of a medical opinion, so now we have to disclose it. Medical care in Iowa, obviously the exact opposite as it is in Nebraska, which means that we get to choose the medical provider. That does not mean we get to choose the medical care that provider orders. It's an important distinction that gets clouded a lot. You get to choose whomever you want to treat the injured worker, and that includes any referrals and specialists. But when the doctor orders an MRI or whatever kind of surgery, we're obligated to authorize that. And it's an important point to make because I think too often people get confused with that. They think that we need to give them pre-authorization before care is rendered, and that's not true. More often than not, the doctor's office will call you and seek that pre-authorization, but it's really just a formality because they want to make sure they're going to get paid more than anything. They don't have to do that from a legal standpoint. So again, just important to remember that you don't get to direct the care. The quickest way to chase that injured worker to an attorney is to start squabbling about what you're going to authorize and what you're not. Okay, and if there is a question, by all means, either call your attorney or call me, and we can certainly talk about it. But if you've got an authorized treating physician who's recommending treatment, that's the treatment that they're entitled to. One of the avenues that an injured worker can pursue if they're dissatisfied with that care is the alternate care petition. And I won't go into a long explanation about that other than to say if you see one of those come across your desk, then you definitely need to call an attorney because there's going to be a hearing on it very quickly. And if you lose at that hearing, you lose the right to choose the doctor. Okay? So you don't have a lot of time. You really don't have time to do anything in terms of getting other opinions. You need to deal with that right away. And they'll obviously have an attorney at that point. Let's see if I can fast forward here. Let's see. Vocational rehabilitation, not used in Iowa, so you don't have to worry about it. If you fire an injured worker, though, that's going to greatly increase their industrial disability benefits, which is kind of the bane of most employers' existence in Iowa because it's an imprecise evaluation. It's essentially an estimate of future lost earning capacity. There's no set formula. There's a number of factors that go into that decision, but the end result can often depend on what judge you get or perhaps what attorney you're facing on the other side. So an injured worker's ability to return to work in Iowa is very critical, especially because of the rural nature of the state, of course. And again, this just goes into a little bit about industrial disability, which I could probably spend an hour on, but I've only got about 3 minutes left, so we'll move a little bit quicker. We don't often use vocational counselors in Iowa, even though we are essentially kind of performing the same kind of analysis they are. I don't like to get them unless the other side gets one first because I don't want to prove the other side's case. Usually don't like what they have to say too often, so we're kind of shy about using them. Common question I get is, I've got a body as a whole injury. My person has gone back to work. Do I have to volunteer any industrial disability payments? You might. You have an obligation to at least ask that question and evaluate it. Okay? If you've got a person who's back to work with no restriction, is doing just fine, well then maybe you can just pay the impairment rating. But if you've got a more serious case, then it is something you have to look at a little bit more. And again, I would encourage you to call counsel, call me, send me an email if you want, and I can give you a quick answer as to whether or not you might want to volunteer some additional benefits. More often than not, if you've got a body as a whole injury, you're probably going to want to seriously consider that. Penalty benefits, big issue in Iowa, obviously. The one thing I'll mention on that is judges do remember. If you have an employer or a carrier and you have a history of making late payments and they have a history of awarding penalty benefits, they're going to remember. They're going to look up your employer's name and find out how often in the past they've awarded a penalty. And if you've got a track record, they're going to give you the max penalty, which is up to 50%. So you don't want to get on that quote-unquote list. You don't want your employers on that because obviously it can cost them a lot of money. Unfortunately, how late is too late is kind of an imprecise question in Iowa. 2 weeks can be too late. Okay? If there's a delay in 2 weeks, you might get hit with a penalty. So as I mentioned on there, pay early, pay often. If you overpay, which doesn't happen too often, we can take a credit for it down the road. Causation, it's much lower of a bar than it is in Kansas. There's no prevailing factor. Aggravations are very common and very easy to get in Iowa. There's some cases in the case law update that deal with that obviously I won't have time to get into. Any questions at this point at the end as we're wrapping it up, literally with 1 minute to go? There are a couple interesting cases in the Iowa update that I'll just kind of point out. One of my favorite ones really quick was an injured worker who was often wheelchair bound. He had a very low mobility, wanted to get a specialized wheelchair to help him get better access on his job, which was in forestry. And the defendant was offering to pay a fairly nice, well-proportioned wheelchair, had nice big mountain bike tires. This guy wanted a motorized wheelchair which automatically stood him up into a standing position at the cost of $18,000. It was on tank-like tracks, so it could go pretty much anywhere. He ordered a gun rack and a fishing pole holder for it, not lying, and the court awarded it to him, $18,000, and they gave it to him. Even though could have had a much less expensive model, the Ford version or whatever. But he got this all-terrain monster of a wheelchair, and court didn't really even blink an eye. The doctor recommended it basically because the guy asked for it. Okay, this injured worker went out and found it and said, yeah, I want that model. That's going to take me down to the fishing and the hunting that I want to do, which was obvious. That's what he wanted it for. But nonetheless, he got it. So you never know when an Iowa judge is going to award you. The moral of that. Again, any questions now or at any time? I'm going to be here all day. I'm going to be here during the happy hour event as well. So by all means, come up, introduce yourself, ask me a question if you've got a particular claim you're working on, and enjoy the rest of the seminar. Thanks for coming in. Appreciate it.